very much for joining us. My name is Alexandra Saibo. I'm a staff attorney at ACUS. I just started with ACUS in February, so I'm very excited to meet those of you that I have not met yet. And I will go ahead and get started by calling off the roll. First, we're going to start with the members of the Committee on Administration and Management. Thank you all to those of you in attendance. And we're going to start with our chair, Erin Nielsen. Thank you so much. And then next is David Apol. Lauren Belmar. Jody Bernstein. Marshall Brieger. Amy Bunk.
Present.
De La Vega.
Present.
Thank you. Very nice to see you. And Bridget Dooling. Next is Tobias Dorsey.
Here.
Thank you. Fred Fielding. David Frederick. William Funk.
Here.
Thank you. Robert Gerard.
Here.
Thank you. Next is Claire Green. Allison Ho. Don Kamensky. Eric Lopresti. Jennifer No. Connell. Olson.
Here.
Thank you. Betsy Panuccio. Elizabeth Papez. Louise Tasikoff.
Here.
Thank you. Bryn Alder Reed. Kate Shaw. She noted she'll be joining us later this afternoon. Lauren Smith. Fire. Jim. On Administration and Management present, whose name I did not call. Of our project consultants, thank you so much for joining us. Joshua Blank.
Hi, present.
Thank you. And Leah Sofsky.
Hi, present as well.
Thank you so much. And are there any other ACUS members in attendance whose name I did not call?
John Cooney.
Thank you very much.
I apologize for coming late. Ann Joseph O'Connell, Senior Fellow.
Thank you very much.
Jim Josie.
Very much. Is there anyone else whose name I did not call? Thank you all so much for attending. I'm going to turn it over to our acting chair, vice chair, and executive director, Matt Weiner, for his opening remarks.
I have no opening remarks other than to welcome everyone to I think this is our second committee meeting of the season, to thank everyone for joining, and especially to thank Josh and Lee for an excellent report. We're very fortunate and grateful to have their expertise. And of course, thanks to Alexandra, who is our newest attorney advisor, and of course, Aaron. So Aaron, with that, I'll turn it either back over to Alexandra or over to Aaron, whatever the order is.
To Aaron, thank you.
Yeah, I will take it. So first we're going to go through the rules, and then I will introduce the project, and then we'll turn the time over to our consultants. So first, the rules. I'm going to get these right. Please note that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates, have full speaking privileges. To avoid background noise, I ask that you keep your microphones on mute and either use Zoom's hand raise feature. Just use, we're not gonna do the hand raise feature. Let's do the comment and the chat feature if you'd like to speak. Then I'll call on you and you can unmute yourself. So don't raise hands, just say comment or speak or something in the chat and I'll call on you then. I'd also ask that ACUS members and their designated alternates use the webcam to facilitate conversation. I understand that isn't always possible. Life is complicated, but to the extent that you can, please have your webcam on. With respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points and will presume the committee members' consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature. For all participants, please use the chat feature only to indicate you'd like to speak. Please do not hold any sidebar discussions or put substantive comments in the chat feature. It's just too hard to keep track of everything that way. Only members of the Administrative and Management Committee have a vote. We're probably not going to vote today, but we'll see, maybe we will. Please do not vote unless you're a member of the committee. We have a list of committee members in case you're unsure. All right, so that is the rules of the road. My introduction here is I'm excited for this project. I read the report, which is excellent. And there's a whole bunch in here that was new to me. Some of this is familiar. It feels like guidance documents. It feels like making things available online, but there's a whole bunch of different stuff here. So I'm excited for this project and I'm glad that we have this good group here. So with that, let's turn the time over to our consultants and however they would like to get us started.
Thanks very much, Aaron. I'm Josh Blank. I'm a professor at the University of California, Irvine School of Law. And my co-author and co-presenter is Leo Sofsky, who's a professor at the University of North Carolina School of Law. On behalf of both of us, I would like to thank Aaron and the members of the Committee on Administration and Management, and also Reeve Bull, Alexandra Saibo, and Kaja Nowaki at ACUS for all of their help during this project and for the opportunity to work on this report and to participate in today's meeting. So we just have a brief 10-minute overview of the topic of the report, and then we're also looking forward to today's discussion. Our report addresses the rise of automated legal guidance across the federal agencies. What is automated legal guidance? A few examples. AIDEN is a virtual assistant created by the US Department of Education who helps members of the public receive answers to questions about federal student aid, such as whether a student loan is dischargeable in bankruptcy. Emma is a virtual assistant created by the US Citizenship and Immigration Services that answers questions that users have about immigration, such as whether a green card holder can travel outside the US to visit an ailing relative without having an adverse effect on immigration status. And the Interactive Tax Assistant is an online tool created by the IRS that answers tax questions specific to taxpayers' personal circumstances, such as whether certain medical expenses are deductible or scholarship awards must be included in income. These are just a few examples of a broader development through chatbots, virtual assistants, and other automated tools. Federal agencies are increasingly relying on artificial intelligence to help the public understand and apply the law. Almost a dozen federal agencies have either implemented or piloted automated legal guidance tools in just the past 3 years. Each year, the federal government uses automated legal guidance to respond to tens of millions of inquiries from the public about the application of the law. Why are agencies turning to automated legal guidance? Agencies must contend with expectations that they will provide customer service experiences similar to those provided by the private sector. We all encounter automation whenever we book plane tickets or check bank accounts. In addition, when agencies explain the law and regulatory programs to the public, they must comply with the Plain Writing Act of 2010, which requires that agency communications be clear, concise, and well organized. Most importantly, agency officials have commented that many members of the public simply are not able to read and comprehend complex legal requirements. As agencies lack resources to hire enough human customer service assistants to meet demand, automated legal guidance is a relatively inexpensive and efficient way for agencies to explain the law. The scholarly study of the use of automation by federal agencies is still in its early stages. Most scholars who have studied AI in federal agencies have not focused on agencies' use of technology to offer guidance to the public. Scholars instead have focused on government's use of artificial intelligence to make enforcement decisions, to design regulations, or to make benefit determinations. Prior ACUS projects have provided important, broad-based perspectives about government use of artificial intelligence, but they've not focused on how the government uses automation to explain the law to the public. Despite the lack of scholarly attention, how the government explains the law to the public is an important topic. Most members of the public lack access to legal counsel who can analyze the sources of the law underlying summaries offered by agencies. This dynamic is exacerbated by the complexity of many regulations and other forms of administrative guidance. For most members of the public, the guidance they obtain from government explanations of the law is critical in shaping their understanding of the law and their behavior. So to summarize our study and our findings, I'll turn it over to Lee.
Thank you. Our report describes the results of a qualitative study of automated legal guidance that we conducted across the federal government. During our study, we reviewed the automated legal guidance activities of all federal agencies and focused on agencies that have introduced well-developed chatbots, virtual assistants, or other related tools. Specifically, we focused on automated tools provided by USCIS in the form of Emma, the Department of Education in the form of Aiden, and the IRS in the form of the Interactive Tax Assistant. After identifying these agencies as the primary adopters of automated legal guidance, we conducted a thorough examination of the tools, principally focusing on how the tools communicate law to the public. And we also conducted interviews with multiple individuals from each agency, as well as with representatives from the U.S. General Services Administration. Each interview consisted of a range of questions, including questions regarding the agency's reasons for developing the tools, process for maintaining and designing the tools, and methods for evaluating the effectiveness of the tools. After describing the results of our interviews and common themes, we offer detailed recommendations in our report that government officials can adopt to reform agencies' varying approaches to automated legal guidance. Our study finds that automated legal guidance offers several benefits to both agencies and the public. First, automated tools provide members of the public with answers to their questions faster and more efficiently than human customer service representatives. Second, agency officials viewed automated legal guidance as helping individuals navigate complex legal rules and procedures, and also aiding third-party advisors such as accountants and lawyers. And last, agency officials described how automated legal guidance enables their agencies to clearly and transparently state agency views on legal issues to the public and their advisors. At the same time, our study highlights potential drawbacks. First, thorough review of agencies' automated tools reveals that they can provide guidance to members of the public that deviates from the formal law. These tools all share a characteristic that we've described in prior work called simplexity, where the government offers clear and simple explanations of the law to the public without highlighting its underlying complexity or reducing this complexity through formal legal changes. Automated tools sometimes portray unsettled formal law as unambiguous, add administrative gloss to the formal law, and omit discussions of statutory and regulatory exceptions and requirements. Second, automated legal tools often provide little, if any, notice to users about some of the drawbacks of the guidance, including failure to capture nuances of the formal law and the inability of users to rely on automated legal guidance tools. And last, without reform, we believe that automated legal guidance may further exacerbate certain inequities in access to the law that different types of individuals enjoy based on their wealth and income, as well as potentially other characteristics. After presenting and analyzing our findings, we offer concrete and specific policy reform recommendations. Many of these proposals are contained in the draft recommendations that have been circulated to the committee here today. And we're happy to answer any questions from the committee and look forward to discussion. And thank you again, as Josh mentioned, for the opportunity to participate this afternoon. Thank you.
All right, so now we're coming to the part where we talk as a committee. Alexandra, can you bring up the recommendations? But before we get into specifics, first of all, just how I see this kind of playing out is we're not going to do the the preamble now. We will get to that for the next meeting. We'll adjust that depending on how the recommendations are adjusted. So we'll just focus on the actual recommendations. Before we get there, just big ideas before we get to like wordsmithing or whatever, just big ideas, reactions, comments, things we need to do to, capture a thought that maybe isn't included or something like that. So with that, I'm going to open up to the group. Eloise has a question. Eloise.
Thank you. This was so interesting. I learned so much. My question is, you just said that many of the recommendations appear in the recommendation section, but so many don't. And one of my big questions is, who did the culling, and can we get some more of your recommendations in the, this is like a question, but a comment that there's almost like a mismatch between the recommendation, the ACUS recommendation, and the recommendation in the report. And so I have specific thoughts about that, but I feel like there's a process story that maybe we're missing, and it would be helpful to say something about that.
Sure, I'll take a stab at it, and then maybe I'll let Matt jump in as well. So the way this process typically works is the consultants are working on the report. They have the first go at it. While they're finishing that up, ACUS staff comes in and starts working on recommendations. At some point, I come in and I have my own thoughts about how to kind of fit in, and it goes back and forth with staff, with consultants, and we put it together kind of something that kind of fits what we've done before, try to draw connections to the other sorts of recommendations, things of that sort. So I guess the answer is that's what happened here is while the consultants are working on stuff, the staff is working on stuff, I'm looking at stuff, Matt and Reeve are looking at it, and we kind of put together just something to get the conversation going. Matt, does that make sense? That
makes sense. And the only thing I just to emphasize your last point, that gets the conversation started. Just emphasize to Eloise and everybody else on the committee that the recommendation is the committee's to draft it at the end of the day, and the staff draft is just a starting point. And so, Eloise, if there are aspects of the aspects of the report that you think should be incorporated in the recommendation, or the recommendation should be otherwise changed, that's for you and other committee members to decide.
That's really helpful. Thank you.
Bill Funk.
Mine's sort of a general comment. There's something in the preamble about it. I don't think there's much in the recommendation, which is, are these automated guidance really viewed positively by the public? I understand that the agencies say that the public likes it, just like private companies say that people like it. But whenever I use the automated information systems from various companies, I always find it very frustrating because I never can get the answer to the question I'm asking. And because it wants to keep you in this automated chat system, it's hard to get out of it and to find somebody who will actually be able to answer the question. And I tried something with Emma just as a test to see whether or not I had the same problem with respect to that government site as I have with all the private sites. And I did. I asked a particular question, and of course it gave me answers, but not the answer to the question I was giving. And I thought, we'll get to the recommendation, but is there any empirical evidence? And I really asking the reporters on this, is there any empirical evidence that the public actually prefers this to the ability to talk to an individual to get an answer?
Consultants, either one?
Yeah, thanks. I'm happy to jump in, and I'm sure Josh has thoughts as well. But yeah, in our interviews, what we found from the agencies in terms of assessing user experience is that it's largely done in terms of user feedback surveys at the end of the experience. So users are asked, how did you like this? Do you have any things like, how did you like this? Do you have any comments, feedback, et cetera? And generally, the agencies described the feedback as positive. But in terms of your question as to whether how do users feel about this relative to, for instance, speaking to a live human being? I'm not aware of any evidence about that or any studies. I don't recall the agency citing any information that they try to gather from users about how they would compare the alternatives. Just as one data point, you mentioned Emma. So Emma, interestingly, one of the, and USCIS has stated this in various public websites, this does not come from the interviews, but one of the goals of Emma, for instance, was to reduce traffic to human representatives, and that actually did not, by and large, occur. So, you know, for what that's worth as sort of a data point about how users are using Emma in particular, it appears that perhaps users are using it as a duplicative source of information, but not ultimately necessarily eliminating their contact with human service representatives as a result.
And I just to add a couple of quick thoughts, just to echo something that Lee said. We heard a lot from agency officials about their own review of customer satisfaction. Some agencies have a survey at the end that people who've used the tool complete, and we're also all familiar with this from the private sector. But we did not hear about studies where groups were asked to just compare the experience of a human customer service assistant versus one of these automated tools. And it's an interesting idea. We didn't hear about it in our interviews. The other point I'll just mention, we've noted in the report for several of the tools, the data we were able to collect during these interviews that we hadn't learned otherwise in terms of the traffic. For example, in 2020, especially during the height of the pandemic, when people couldn't reach officials at the IRS, the interactive tax assistant received over 5 million visits. And that was higher than a normal year, but still every year it's millions of visits. So don't know if that exactly answers the question of how satisfied everybody is, but at least a lot of people are using these resources across the government.
All right, I think Nina Olson.
Yeah, hi. Well, to Bill's question, my former office in 2016 and 2017 conducted a survey, a nationwide survey that was representative of individual taxpayers who had used various forms of IRS services online, including whatever chats were available at that time, ITLA, on phone, and also in the walk-in site. And we found that the majority of people who went online were dissatisfied with their experience, did not get the answer the first time that they attempted, and had to seek other avenues like the phone, etc. We also found that the impact was very disparate on the elderly, the disabled, and the low-income taxpayers, and that particularly in that population, they all preferred to have a person-to-person interaction, namely on telephone, to get answers, whether it was tax law or to their account-related things. So that's a very rigorous 95% confidence level survey of taxpayers who are actual users of customer service along different modalities. And we covered it in 2 years of my annual report to Congress in the research section. I think it was 2016 and 17. If I can find it, I'll put the links in the chats, and I'll be more than happy, Josh and Lee, to talk to you about that, because we had a lot of recommendations coming out of that one.
Perfect, thank you. Jim Tozy. I don't hear you, Jim.
You can hear me now?
I can hear you now.
Thank you. My experience tracks with the previous speakers that I would prefer to speak with a human being, but I just wonder if that's a real comparison nowadays. Agencies are just strapped for a variety of reasons with lack of resources. So I just wonder if that's a viable alternative anymore. I think the nature of the administrative state is so complex, people are going to have more and more questions. And I just sort of doubt whether we'll ever get that kind of human interface. So it seems to me that the other part of the side of the coin is really what are the options? And I think the option is going to move towards this type of automation to get that kind of answer, because I'm not sure the other options, how viable that is anymore.
Anybody else would like to speak on this topic? If not, I'll put myself in the queue. I think this is really helpful. I appreciate people raising the issue. I think again, this is me speaking, is just me, not as committee chair or whatever. It seems like that should be useful as we, think about what the recommendations say, that we don't necessarily affirmatively encourage agencies to do this. It's more of the, if agencies do this, these are the best practices. But those are questions, a little bit like beyond what we can say here, whether they should or should not. Those are questions about budgets and all sorts of things. But if they're going to do it, we should make sure they do it as well as they can, but maybe not yet affirmatively push them that direction. Anybody else want to be heard on this one? Maybe again, Lee, Josh, would you like to be heard on this before we kind of move on to specifics?
And just to say thank you for the feedback. And again, just to be clear, we were only responding in terms of what we heard from the agency officials. So some of the resources, such as the survey that Nina addressed, I want to make clear that's not something that we were describing. We were just describing what our interviews were like and what the agency officials reported to us. So to the extent that there's a mismatch, that's also, I think, valuable information for the committee to have.
Yeah, I'll just agree with what some of Jim's comments in terms of the resource constraints that agencies are facing and some of the reasons why they're turning to some of these tools. So for instance, Nina mentioned the IRS context, and we've seen the sort of ability to get through on the phone get more and more difficult at the same time as we've seen the IRS continue to advertise the interactive tax assistant as an alternative. So I think some of those dynamics that Jim described are definitely explaining part of the reason we do see the agencies turning to some of these tools.
Bill Funk.
I wanted to say, I understand exactly what Jim Tosi was talking about, and I understand why agencies want to go to this route, just the way private industry wants to go to this route to save money, save resources. And so the idea that we're telling the best practices, not necessarily encourage them, I think is a good idea. I do think it's worthwhile to think about which kinds of agencies need this more than others, or are best served by this than others. Agencies like the IRS and immigration, who deal with a lot of individual, ordinary people, the idea of having a chat box to answer some questions may be a good idea. But if you get something like the Securities and Exchange Commission, Federal Communications Commission, or EPA even, or OSHA, they regulate businesses, they regulate entities that have a little bit more savvy. I don't think that, law firms are going to use chat boxes to try to figure out what the agency's rules are, although they might try to use them as a way to challenge an agency's actions if it's inconsistent with what's on a chat box. So I just wonder, in terms of which agencies and what kind of people are we trying to reach here, as opposed to other kinds of people.
So I hear you. That makes sense to me. Do you think that would be a recommendation point, something in the preamble to kind of frame the discussion? How do you see that idea fitting in, Bill?
Well, I can't say that I thought about where to fit it in. This was sort of the big picture ideas that we're talking about here. And when we get to the recommendations, we're talking about agencies that are in fact going to do it. So then the question is, let's focus on who is it they're trying to talk to, and the idea that it's going to be the ordinary citizen is the most likely person to do that. And so it should be framed to try to do that. And I think a lot of the recommendations take that approach. So that's not a problem, but it's just something I think we should keep in the front of our minds.
Right, Eloise.
I think that some of these initial comments go towards having an initial part of the recommendation that's its own new subsection. I don't know how we typically, I can't remember how we typically style such things. Calling it like preliminary matters seems not exactly right, but that's kind of what I mean. And Bill's suggestion there seems like it fits there. Some of Jim's suggestion seems like it might fit there. Some of what Tobias commented on initially seems like it might fit there. I have some other thoughts about some other things that might fit there, but I'm just throwing out there that some of these macro comments I actually think are more framing for the recommendations as like initial considerations before agencies get into the specifics of what the best practices even are.
Yeah, maybe Reeve or Matt, how do we typically do that? What do we do for kind of like macro thoughts in a recommendation that are not preambular, but are actual recommendations?
Yeah, I'm happy to weigh in. So I think, if I understand correctly what you're describing, Eloise, I mean, I think generally, typically what we would do is maybe have like a more general section at the outset, and we can title it whatever we want. It's just sort of fundamental questions before we get into the specifics. I think that seems to be more what you're talking about, as opposed to preambular matter that's not really recommendation focused, which would then sort of go in the last part of the preamble. But if there are sort of these fundamental questions, what are the optimal, or what sorts of agencies are best positioned to use this type of technology, or that sort of thing, I think putting it in sort of a general section preceding, they would include a number of recommendations, but they would precede the other recommendations, the more specific recommendations. I think at least traditionally that would be sort of the way we would approach it.
Okay, well, let's start talking about specific language then. I like the idea, Eloise, of having some sort of general thoughts that incorporate some of these thoughts that we've heard. I'm not sure what it would look like. I think if I may, I'll ask the staff to look at what they've done in others, and we can kind of mirror that language. But what would we include there if we were to do this? Let's say right now, let's call it general. Let's just call it general. And what would you include? Can I call on you again, Eloise, here? Is that fair?
Yeah, sure, that's fine. So for example, I think that the suggestion that Tobias sent in, or that the staff turned into the first sentence that's now under accessibility, I think that should come up. And I think that should be the first. Agencies should explore the possible benefits of exploring automated legal guidance tools. But I also think it's fair, and I had sort of jotted something like this down based on the section in the report. Agencies should also weigh the potential downsides of the, we could even summarize what those potential benefits and costs are. So that from the report. So that was one thought I had about what would go there. I thought Bill's suggestion about, I like Bill's suggestion so much that I'm also now uncomfortable with the phrasing agencies here. And so I think it might even be agencies, especially those who serve especially those with high volume, individual facing blah, 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 should consider, I'm making this up, Bill, but I think that might capture some of what you're talking about. And then I did have some other thoughts of like cutting and pasting of stuff to move into this section, but I don't know if you want me to go, that feels like it's kind of jumping ahead, but I have at least two other thoughts about what could go in this initial section. And I also noticed Tobias had his hand up and then put it down. I don't know whether you wanted to call on him, but.
Let's call on Tobias. Let's go. We'll circle back to you in a second, but let's call on Tobias.
Hi, everybody. Thank you, Eloise, for carrying my water on this. That what you were just describing is exactly what I was aiming for. When I got to this recommendation, my initial sense was that all of the recommendations I was reading were like what I'll describe as they were all in the middle of the pond, and I hadn't figured out like whether I was supposed to put my foot into the pond or not. And I feel like there needed to be some kind of big picture. Yes, ACUS is blessing agencies to go forward and think about this. Maybe not do this, but to think about this. And here are some of the sort of substantive considerations you should think about as you do it. And I sort of thought that the very last sentence of the preamble, which I wanted to strike, was kind of hinting at that. So yeah, I think the suggestions that have now been typed in are great. I would also, and I think we should talk about the weighing the advantages and the disadvantages. And I also think that focusing on agencies that have this big customer, base to interact with, that makes sense. Although the one sort of wrinkle I would add here is that I think that agencies ultimately, they need to do things to promote or further their own mission needs. I tripped over the part of the original recommendation that said, they should meet the needs of the public. I mean, they should meet the needs of the public to the extent that furthers their mission needs. We don't have an overarching mission to meet the needs of the public. We have an overarching mission to carry out our statutory responsibilities. So I'll stop there.
Yeah, let's put a pin on that. When we get to the actual language in that sentence, we'll talk about that one. I agree that we could talk about that. But right now, I just want to get the ideas. So you're okay with, if I'm understanding you correctly, with Eloise's kind of general framework at the beginning?
100%.
Okay, cool. All right. Anybody else would like to chime in on what we've got so far? Again, we're not talking individual language yet. We'll get to that, but just conceptually. If not, I will turn it back to Eloise to add some more of her thoughts. Hearing none, it's yours, Eloise.
So I really like the last recommendation on page 45 of the report, which I think speaks to some of the concerns that Nina and Jim and Bill, it's just all of the weighing the downsides, I think, are captured in this, because I think as ACUS, I do not feel comfortable leaning too heavily on these tools without putting them in the context of a broader set of such tools. So the recommendation in the report says agencies should supplement automated legal guidance. I would even soften that probably. If agencies use automated legal guidance, they should not see these tools. I think we will both wordsmith this, and I assume people will push back on this as well. But as efforts to replace other avenues that increase access to the underlying law, period, agencies should instead see automated legal guidance as part of a portfolio of such access. I'm now thinking about Tobias's last point, to the extent it fits with their statutory mission, but then the pro bono legal services and increased training of customer service representatives. So I'm not sure that may be too much, but I worry about leaning too heavily into this as a replacement opportunity in light of the last couple of comments from Nina and Jim and Bill, and wonder what others think.
Was that, you mentioned you had a couple ideas. Did you combine them into one?
No, I mean, I just gave that one. Did you? I mean, so the other thought I had.
One more, and then
okay, sure. The other thought that I had for what could go there would be the recommendation, like that in that little recommendation, not the big report, but recommendation 14. Agencies should adopt clear procedures for designing, maintaining, and reviewing. That just seemed like a introductory comment, not a thing at the end. That's like, if you're going to do this, here's some best practices for how you should set it up. So
yeah,
that
makes sense to me.
That was my idea. And then the last kind of substantive point I had here is that I agree with what's now the second sentence of the first recommendation, that when agencies choose to offer such tools, so it's like Tobias's suggestion to move that last sentence from the preamble down to recommendation. But this is where I was asking about the mismatch between the report and the recommendations, because I don't understand where this list of values comes from. And they're also different from the values that the report walks through. And then also only some of the words are replicated in the recommendations. And so I got a little lost in why these are the values, but also the mismatch of operationalizing them, I was not certain about. So that's, I mean, I could summarize I could go now to the sentences in the report, but I would recommend, this is also like a question about, was there some decision to change the values that the report had? That's a little bit what I meant by the process points. So that was all
I can explain, I can answer that one. I urged the staff to try to make this recommendation consistent with other recommendations. So we have recommendations about guidance, and we have recommendations about, plain speaking and things of that sort. And I wanted to make this fit, more consistent with the whole body of what we do. So I had asked them to look at some of the others and use it that way. It wasn't an intentional slide on my part on the report, but I wanted people to look at this with all the others that we cross-reference. So if I left out one of the values that you think are particularly important, then let's put it back in. It wasn't intentional. It was just, I didn't want to recreate the wheel. All right, I see that Nina has a comment.
So I think both in 4, where, the general comment, and then 2 under accessibility, I think we could add something about, this goes to my point about surveying, like, what does reviewing mean? The agency itself sits there and says, yeah, this works for us. This is great. We think it's clear. And you don't have any external evidence or, very specific drill down. I've seen the surveys that they do at the end of these chatbots. Were you happy? Or, yeah, you might be happy because you finally got something, whereas you'd been sitting on the phone for a while and couldn't get anything. But did it answer your question? Are they asking those questions? I think that surveying is very important periodically, in a general way, and also vis-a-vis other modes, other channels of communication. And so that you're not just looking at these tools in a vacuum, but you're comparing them to the effectiveness of other forms of explaining, whether it's FAQs on the website or it's actually having a helpline, a tax law line, for example, that people can ask. And then I think also for user testing, we need to make clear who they are testing it with. Are they testing it with, if it's for the general public who can't necessarily afford legal advice, are they testing it with people who are members of the general public? I know at the IRS, they have a user lab that they often use their frontline and phone assisters to test the products. Well, they're already part of the IRS. They're not general users. So those are like refinements, but I think that those are very important because otherwise the agency can just check this off and say, yeah, I did it.
Does anybody else want to be heard on that? I that makes sense to me. Now I'm just thinking how we operationalize that, but I think that all that makes sense to me. Anybody else want to be heard on that? Okay. All right. Well, here's a thought. So I think how about this? I just kind of take a straw poll. Does anybody oppose adding a general section to the start of the recommendations? Is everybody on board on that? If I was in a room, I'd look around and I get a feel for the room. I don't have that, so you have to speak up if you're not. I think that makes sense. I'm a little bit worried about us just coming up with completely new paragraphs of language on the fly. So I'm inclined to say that if we get the ideas that we want, then we can, between this time and next time, we can come back with some language that, more specific to shoot for. And then we can start looking about some of the other recommendations that we already have language for now. So that's what I propose to do, unless anybody wants to not do that. Nina, I hope it's fair. It'd be great if you could come up with some language that captures that thought that you just had.
Sure,
It'd be really helpful.
Sure.
If you could send that then send it to us between this meeting and next.
Yeah, I'll work on that.
All right, perfect. Thank you. All right. And again, Eloise, I hate to punish people who come up with helpful advice, but could I ask the same for you as well? especially on some of these, values and principles that we are including what you think I've missed.
Happy to do it.
Perfect. All right. Thank you. Okay. With that, then we will put a pin in the general section. Between this meeting and next, we'll go through and we'll wordsmith it out, and we'll add some of these things from Nina and Eloise, and then we'll have time to discuss that at the next meeting. So let's put a pin in that. I'll let you, Alexander, write that down, and then let's move on to the accessibility suite. All right. Okay, so we have the first one, which is agencies should utilize human-centered. I think that's going to fit into the general, right? Is that the accessibility? Or Tobias, I think that was you. Where do you see that fitting in?
I agree. Well, I mean, it definitely could fit under accessibility, depending on what we mean by accessibility. I had raised a question. I wasn't sure where this came from. I gather from I think what the staff comment was on the side is that this comes from an executive order, but I hadn't seen it in the report, so I didn't really understand where it came from. But I'm fine with it in some form or other, and I'm really agnostic about whether it goes in the general section or here.
Yeah. So let's just back up again. I think Matt made this point, but it's important. The report is really important. Folks can look at the report. It's going to be part of the ACUS webpage forever. It gets distributed, cited, whatever. There is obviously some relationship between the report and the recommendations, because that's where we're basing it on. We have our consultants, but the report also is the committee. So it's not just like our consultants come up with some ideas and we put it together. It really is should be an iterative process with everybody on the committee, including things like executive orders and things of that sort. So that's why that came in. I'm not sure, that could have been for Matt or Reeve. I'm not sure where that came in, but that isn't necessarily a problem. If we don't like it, it's a problem, then we could take it out. But the mere fact that it's not something or it's not in a report is just par for the course in the committee process.
So if I may,
that's
can
exactly
I just,
right, Aaron.
go ahead, Matt, go ahead.
I mean, that's exactly right, Aaron. And, sort of using an administrative law analogy, it's not a sort of an exclusive record proceeding. We're not limited to the consultant's report. And, to use another administrative law analogy, there's no deference owed to the staff. So.
Correct. And sometimes it's good to make the staff, earn their keep. So that's great too.
So then what I'd like to suggest about this is that someone make an effort to put this in plain language, because I can't really wrap my head around what human-centered design methodologies actually means. So I'd like someone to take a stab at that if we're going to keep it in.
That seems fair. All right. So I'm debating right now. Should we ourselves right now? Is that too big of a bite for us to try to come up with language there? Or should we see what happens between this meeting and next? I'll start back at you, Tobias. What do you think? Should we try to wordsmith it now, or do you want to see what we can do between this meeting and next meeting?
If I could jump in here, I would suggest, whoever came up with the language, human-centered design methodology, should be the one to try to rephrase it. And I don't know who came up with that language, but that they're ones who knew what they meant. And so therefore they're in the best position to try to say it in a way that we can understand it.
Jump in here because I'll take credit on the staff side for this. As Nina Olson points out, it is actually defined in EO 14058. There it refers to an interdisciplinary methodology of putting people, including those who will use or be what one creates, at the center of any process to solve challenging problems, and is considered to be critical in designing customer-facing digital services.
So we can blame the executive order.
Correct.
Well, maybe it's worthwhile to make a reference to it then. center design methodologies as described in the executive order, blah, blah, blah.
And it seems related to the comment about the Plain Writing Act.
Yes. No, I think as an academic, if somebody wanted to write a snarky law review article, they could apply the Plain Writing Act to a bunch of executive orders and see how they do. But I'm not saying I should write that article. Somebody should write that article. But all right, let's do that now, and let's go back and we will see if there's any better language we can find that does that for the trick. So let's put a pin in that one. We'll put a pin in everything, but these are bigger pins. We'll put a pin in this one, and we'll see what we can look like between this meeting and next. Okay, let's look at 2, which is initially where we kind of started. And let's let everybody read this one, because this one I'm hoping we're not going to put a pin in. We're gonna get it sorted out here. Everybody give it a read, and then we'll see if anybody wants to be heard on what is now 2. The one that agencies should, consistent with applicable laws and policies. Bill, would you like to be heard? Let's put it in the comments so I can keep track. All right, would anybody like to be heard on what is 2 on our screen? All right, Bill Funk.
I'm with Tobias that this is that they meet the needs of the public that are meant to be served isn't really what should be said here. But I think it's also more than just say meet the statutory needs of the agency or to follow the statute. Here, the idea is you're going to look at these periodically to make sure that whatever it is you're trying to communicate to the public is in fact successfully being communicated. And that's what really comes back to why this is under accessibility, is we're trying to say that, are you being to review this to see if you're successfully communicating to the public what the agency wants to communicate to the public. That's the best I can do in terms of wording, but that's what I think the idea.
I mean, I guess, what if the agency wants to communicate things that are unclear? That's not right. We want the agency to have a higher standard than what the agency might be inclined to do. We want them to convey at least accurate information.
Certainly, I didn't mean to suggest otherwise, but here it's just this phraseology to ensure they meet the needs of the members of the public they are meant to serve. And the question is, is the purpose to meet the needs of the public? Or, I mean, as Tobias said, it's really to meet the needs of the agency, right, in communicating to the public.
Eloise.
I feel like this section is coming from the reports section, which is called accessibility, inclusion, and equity. And with that as the frame for what recommendation 2 was supposed to be about, I think recommendation 2 is supposed to be about like evaluating, who is using our automated legal guidance? So that's the recommendation number 1 of this section of the report, was about demographically figuring out who's using it and then trying to make sure that whatever's being offered is meeting that demographic's needs. So I guess I feel, and I think that this is sort of like, are we meeting the needs of low-income taxpayers? Are we meeting the needs of perhaps non-English speaking underrepresented immigrants? That's what I think it's supposed to be conveying. And so I I agree that meet the needs of the members of the public they are meant to serve is maybe more general than is being conveyed by that, but I think there should, I'm not wordsmithing this properly, but we need to say something about agencies should evaluate the demographics, which is I think part of what the report is about, of who is using the chat, the services, and make steps to, I'm losing the thread here, but it's not the needs of the public. It's about the particular demographics that the bots are serving. I don't know if anybody wants to take a stab there.
Nina?
Yeah, I think that's how I read it, that these tools are designed, it's not just the people that are currently using it, but what is the population that needs access to plain language legal guidance? And then are these tools designed to be usable, accessible by that population? So and then you should periodically review the design and the demographic, the population that needs that plain language legal guidance, because it may change over time, and then adjust accordingly. So I think the first part is the design, and then the second part is the periodic review. And the focus is first articulating who these tools, what populations these tools are supposed to serve. In your review, you're also saying, were they effective in serving that population? And if not, why not? So I would break it out into the design and then a second piece on the review.
So 2 or maybe 3, right? Design.
Yeah, I would do 2 is design, and I would include in there, identify the population that needs access to these tools and design them with respect to the needs of that population.
Let's see if we can get words on a page.
Yeah. But consistent with, design, for what, I don't know where you would fit in, consistent with the particular demographics of the population. Of the population. Well, how about that are intended to utilize? Because that means you've targeted, you've said, these are the people we're trying to give this guidance to. And then the second piece would say periodically review to make sure they, and update, I guess. I don't know, periodically review to ensure that they meet the needs of the public they are meant to serve. I don't know whether that does it for people.
I think we should use the same language in 2 and 3 about public. So I think we'd use particular demographic again.
Mm-hmm. And update might not be the right word, because some people might think, well, that just means you're updating the legal guidance that's out there. And what we're really talking about here is design.
Yeah.
I'm not sure what the right word would be.
Reconfigure, that was a nice one. Nice job, Alexandra. All right, and then we would get rid of the Eloise's draft language. And we got thumbs up from that one. Great. Okay, all right, comments on this. Again, we can tweak the language, but are people okay with where we're going here? Would somebody like to be heard? Okay, hearing none, are we okay with the language? Are we okay with the language as it now reads on recommendation 2? It seems to me, Bridget, the floor is yours.
Hi, sorry I'm late to meeting. I'm excited about this project. I wonder, do we lose anything if we strike the word demographics of the, I guess so it would be needs of the particular population?
Nina or Eloise, do we lose anything by cutting demographics and just going particular population or populations?
I think it's better. I like it. I mean, what Bridget says. I like what Bridget says. I don't think we need anything. We need the language.
Are you okay with that, Nina?
Yeah, I'm good.
All right. I think we should say population or populations or just because sometimes we multiple audiences.
Yeah. With different needs.
Yeah. Okay. Thank you, Bridget. That was very helpful. All right. Anybody else? Okay. All right. Let's look at number 3, the new number 3 about review and reconfigure. Would anybody like to be heard on that one? And we still have the language there meant to serve. I mean, shouldn't it be the same as before that are intended to utilize the automatic legal tools for consistency? All right, Eloise is giving me a thumbs up, which I take as a license. All right, Tobias, can I circle back to you? Does this work for you? Okay, hearing no objection, it does. All right. Okay, anybody else will be heard on that? If not, we'll go on to what is now number 4. Okay, all right, let's go down to what is now number 4. All right, take a second, everybody read it, get it in your mind, and then we'll talk about it. Okay, would anybody like to be heard on what is now number 4? All right, I'll put myself in the queue for number 4. I like it, but I think we should use the same language from 2 and 3 about members of the public, so we have symmetry. All right, anybody else would like to be heard on this one? All right, hearing none, let's go on to number 5. Okay, say a comment, Eloise.
Sorry, I would love it if we moved the stuff with semicolons to the end of the sentence. So instead it says agencies should ensure that information provided by automatic legal guidance tools is stated in plain language, understandable by the particular populations that are intended to utilize, comma, consistent with.
I like that. For those of you who have not, who this has been your first time going to these meetings, Eloise is my go-to person for wordsmithing. If she had, she's an amazing scholar, but her real her real comparative advantage is she makes things read really well. So thank you, Eloise. Thank you. All right. Okay. All right. Any objections to that? Any further comments? If not, let's go on to number 5 here. +1, Eloise is the best. I say no substantive comments in the chat, but I will make exceptions for that. So that is great. Thank you. All right, let's look at number 5. Everyone get it in your head here and then we'll talk about it. I'll give people a couple more seconds, and I'll turn the time over to Bill. All right, Bill, the floor is yours.
I particularly like this provision because it makes clear that they ought to tell you an easy way to talk to a person. But I think instead of addressing additional questions, blah, 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 it should be address questions not answered by the automated legal guidance.
And then delete the rest of the sentence.
Yeah, delete the rest of the sentence, yes.
All right. Would anybody like to be heard on this one? Is that your hand, Nina?
Yeah, I was just going to type it in. I think you should keep the, if they are having difficulty, I mean, that is an access issue, you know, delete the or understanding the information. But I think there are two things. The question you're not getting the information you need from the tool. You have, you know, questions that the tool itself hasn't answered things, or you're having actual accessibility issues. You know, you're not able to see it properly, you know, or whatever. It's not working with your reading software, things like that. So I'd leave that part in.
Is that a friendly amendment, Bill?
Yes, it is.
Great. I agree. I agree with that thought too. Thank you, Nina.
Yeah.
All right. Anybody else like to be heard on this one? Eloise.
This is a question before we move to transparency. It's not on question 5.
Go for it.
So I might have missed this in the report, but was there something about access to users with disabilities? Because the very language accessibility makes me think of compliance with ADA, or I actually don't know if 504 is, I don't know the status of 504 in federal agencies, but so this is maybe a question for the report writers, but the word accessibility makes me feel like we should have something about that here.
Josh or Lee?
I mean, in the report, we do talk about how disability is one characteristic that agencies should study. And that was what we were referring to in that section titled Accessibility, Inclusion, and Equity. But we don't get into any of the statutes or other requirements that might apply. We just raised that issue in that one section that Eloise mentioned.
But do you think more generally it would be valuable for us to say something more affirmatively, either about law compliance or making sure, I mean, there is something really, it's not just generally accessible to the public, but really making sure that users with different disabilities can access it. Anyway, question about that.
Yeah.
Matt or Reeve, do we have a recommendation on this subject? Or Jeremy or somebody else?
Nothing is immediately coming to mind. We can look and see. There may well be one where we've spoken to this issue, and then we can try to match the language.
No, I agree. I think Eloise, you're spot on. We should have something where we're clear that we're talking about public specific populations, but then also particular folks who might need help with accessibility that are different and unique. I think that thought should be captured somewhere. Try to see where that would look. Can you scroll up, please, Alexandra, so I can see the earlier ones? Because that could be included in what is what we're going to do with number 1. Right, we're going to rephrase number 1 to make it broader and easier to understand about accessibility. We could add a thought there about, I would think, you know, making sure it's accessible to, you know, regardless of one's ability. Does that work, Eloise, like conceptually?
Yeah, though I think I would prefer to say people with disabilities rather than regardless of one's ability.
Oh, yeah, no.
Ability,
I'm not trying to use that language.
Yeah.
I'm just saying
Yeah.
Like, yeah, no.
I captured it, and I like putting it first. I think that's nice.
I see, Lee, the floor is yours.
Yeah, thanks. Yeah, I just wanted to respond as well. I mean, just to flag one other thing for you, which I don't know if you would want to sort of broaden the concern a bit or not, but one we had recommended in the report to sort of consider the demographics of who's using the automated guidance. And so one concern we might have is about people with disabilities. Another concern we might have is about sort of other subgroups and the extent to which they're able to use and rely on the automated legal guidance. So for instance, rurality is a group that the access to justice literature focuses on. So people who might not have as reliable of internet access, et cetera. So I don't know if we do want to consider, something about, sort of more general study of the demographics of people who are and aren't able to use automated legal guidance and their experience with it. But that was something we focused on in the report to some extent.
Jeremy, is Executive Order 14058, which I confess I did not read before today's meeting. Does that cover some of these issues more broadly, or is it more specific?
I mean, the approach that EO takes is somewhat iterative. It builds on, I think it's EO 13985, which is the equity EO issued in January of last year, which refers to, I believe it's historically underserved communities. And that definition includes things like rurality, persons with disabilities, those sorts of communities.
Are we talking, part of, just maybe I'm not following this exactly, but is the concern here in part 508 compliance under the Rehab Act? Is that what we're talking about here? Because if that's the issue, I mean, I'm not saying that these other issues aren't important, these other equitable issues, but 508 is just a legal mandate. And I don't know, Reeve, I don't know how we've, we could sort of think about this. I don't know the extent to which we've addressed 508 compliance in other recommendations, because this is certainly not the only context in which 508 compliance would come up in ACUS recommendations.
Exactly.
All right, so I'm going to give Reeve some homework on this one. Reeve, we want for accessibility, for number one in the recommendations, we want to capture these thoughts consistent with how we have done it before, at least have language that kind of looks like that. I don't want to recreate the wheel here. I think Matt is surely right. This isn't the only one this would come up for. So can you figure out, Reeve, what we've done before so we can at least look at it? And then obviously if we decide we want to do something different, we can, but I don't think we need to recreate the wheel on the fly.
Yeah, happy to do so.
And the recommendation that Jeremy served as the reporter for, the consultant for remote video hearings, among others, those issues were front and center of that recommendation. So there's definitely material from which we can draw by way of offering some options to the committee.
That would be really helpful. All right, Eloise, with that understanding, this was your comment that we went down this thing. With that understanding, are you okay to move on to the next section?
Absolutely, thank you.
Awesome, thank you, everybody. All right, we've been going at this for an hour and 15 minutes. I'm inclined to go for another 15 minutes and then take a quick break. Is that okay for everybody? All right, let's go. Let's go for another 15 minutes here. We have transparency. So on the transparency suite, before we go through the individual ones, did folks have thoughts that, or additions, subtractions before we get into individual recs? All right, hearing none, let's look at what is now number 6 on our page. Let's everybody give that a read and then we will discuss. Okay. Just to mix it up a little bit, I'm going to ask our consultants, this is a good part of a significant chunk of the report deals with this type of issue. Does this give you heartburn? Either Lee or Josh.
No, I'm pretty happy with this recommendation.
Yeah, I'd agree. It's not the exact words we used, but it's the same idea.
Right, perfect. Thank you. Bill Funk.
I guess I didn't quite understand. I mean, I understand that sometimes automated legal advice or any kind of legal advice that's not particularly tailored to a particular situation might not be applicable, but I just could clearly indicate that the information provided may not be applicable in all cases. I just didn't understand what about in all cases that are directly on point, or in cases that this, I just didn't understand why you could say that, you know, it's good in some, but not in others. I just didn't understand it.
I think what we're trying to go say here, Bill, is this is the simplicity concept that comes out in the report, which is often law is really complicated, and there's a guidance that might apply 99% of the time, but might have some one-off exceptions or something like that. And you want to at least let people be aware that there's more going on here where we have underlying complexity. I don't know if this language does that, but I think that's the concept that we're trying to do here.
Well, I understand that, but the idea is if it's applicable in 99% of the cases, and you say, here's our guidance, but it may not be applicable in your situation. I mean, that's not very helpful, right? To say, here's guidance, but don't, if you want to say, here's guidance, but don't rely on it because of X, Y, Z, that's one thing. But to say, it may or may not apply to you. I mean, that's no guidance at all, is it? I mean, to an ordinary person, and you say, here's the guidance, but it may not be applicable to you. That's not very helpful, I don't think.
Lee.
Yeah, this was a reaction I was having when we were having a general discussion at the beginning about sort of when, what types of agencies should be using this type of guidance. I think that there's a second point, which is sort of when, within an agency, under what specific circumstances is the guidance particularly useful? And sometimes agencies can give very reliable responses to complicated questions that users wouldn't be able to figure out themselves. Such as, for instance, do I have to file a tax return this year? Perhaps based on the facts, the answer might be clear, although it might have been very hard for the user to figure it out themselves. And in other situations, the answer is very unclear because there's a lot of conflicting law, or it depends a lot on facts. And right now, users don't really have the ability to sort of sort through when they're getting very reliable advice versus when the answer is really going to sort of depend more on the situation. And so perhaps that's what Bill's getting at, that rather than just sort of having a disclaimer that the information may or may not apply, it might be helpful for agencies to sort of flag more concretely when the answer is more likely to depend on certain circumstances, and that additional expert guidance may be needed.
I think that would be helpful. When I do my TurboTax, right, it has a thing that says, in unusual circumstances, this may apply. I just skip that because I figure I'm not an unusual circumstance. And at least I know that normally this won't apply to me. And so the idea that, that this guidance would say something like normally, all right, but just an open-ended say it may or may not apply, I don't think it's all.
Does anybody have proposed language to capture this thought?
I don't know, this is a suggestion.
Sure.
Agencies should clearly indicate in automated legal guidance tools the extent to which the information provided may not be applicable in a certain case, or
Does anybody have reactions to that language? Lee, does that work for you?
Yes, I think so. Josh, do you think that agencies would be capable of sort of identifying in what situations the information is may not be applicable, or is that too heavy a burden to put on agencies?
Yeah, I think that this works. Our main goal, just speaking only as consultants now, was basically to make this point that sometimes the underlying law is not as clear as how the agencies describe it. And so we just want to try to create an opportunity for anybody who goes to this site to, at least in those situations, question whether they might want to also talk with somebody else, talk with an accountant, talk with another advisor. So I think that this recommendation, I mean, that's the general idea of what it's trying to do. I think that this works even with this new language.
Yeah, I'm just, I mean, the problem is, it seems to me like unknown unknowns, where if you know it's going to not be applicable in certain cases, then you should say so. That's right. That makes sense. But sometimes the law is just really confusing in ways that the agency might not itself know what the right answer is. And then if we say in certain cases, that might indicate there's more certainty than there is.
Let me try a different approach, because I mean, if this particular number recommendation is only dealing with, or almost always dealing with, situation where the underlying law is unclear, why don't we say something like, when the underlying law is unclear, agencies should identify that the advice given is tentative, is tentative advice, and the person should not rely on it to their detriment, and then provide access to underlying legal documents. Because if that's what we're talking about, the law is unclear, the agency's taking a first stab at what it thinks it means, but it's not clear. And therefore, in that sense, nobody should ever rely on it, but they at least know where the agency's coming from.
All right, comment from Lee.
Yeah, I'll just jump back in here just because this is something that we've thought a lot about. So, I mean, part of the issue sometimes is that the law is unclear, but part of the issue is that the agency doesn't have so this is sort of to Aaron's unknown unknowns point. So part of the issue sometimes is that the agency doesn't have the full story. So the automated legal guidance asks a question and the user answers it, but there's other facts that would be relevant and sort of change the answer or modify the answer. And so then the automated legal guidance gives an answer, which actually isn't necessarily the right answer based on the sort of full set of facts, but the user doesn't know that and the agency doesn't know that. And sort of the nature of the automated system is that the user thinks it has the answer when actually there's sort of more complex story. And that's one of the issues with automating, right? If you were sort of in a conversation with a human being, there would be sort of a fuller sort of discussion. So I don't know if that's captured here, but I see that Josh has a comment as well.
Nina, can I have Josh jump in and then give it to you? All right, Josh, then Nina.
Just one small point. In the report, we talk a lot about this topic, and it's not just a question of whether the law is unclear, but it may just not be settled because there are different courts that have addressed an issue in different ways. So just because we talk about it in the report, I wanted to mention that it's not just that it's unclear because it's so complex. There may actually be a conflict in terms of how different courts apply different standards, interpret certain words. There are a lot of other examples that we've talked about in this report and other writing, but I just wanted to mention the unsettled point, not just a lack of clarity.
Yeah, do unclear or unsettled. All right, Nina, the floor is yours.
Well, I also think it's where, to Lee's point about the facts, sometimes the law is clear, but there are so many different factual variations that the law applies to that in general, blah, 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 doesn't give you the right answer. Yeah, maybe that does it with disparate, factual circumstances. And what you want is to flag that to the person. And that goes to the recommendation above, that where you don't, in those situations, you want to have the ability to go not just to an advisor, because the targeted population may be one that can't afford an advisor. So you need the agency to provide a different means to be able to say, well, here's my situation. You talk to a human being then. Or you have a much more advanced artificial intelligence tool. And I am thinking specifically about, the IRS's ITLO, which is designed to answer questions about the earned income tax credit. Well, that is the low income working population. And they have very different family arrangements, and a broad answer may get you a significantly wrong result.
Bill, last thought, and then we'll take a quick break.
I just don't think that belongs on this particular numbered recommendation. I think it should be dealt with separately, right? I think there's a different issue when the law is unclear and the agency is giving tentative and settled unclear. And there's a different issue when the facts are, it really depends on a lot of facts, and the artificial intelligence stuff just doesn't deal with all those different factual situations. But I think that's just a different concept and ought to be dealt with in a different numbered recommendation.
Feels like that should be the next recommendation after this one.
Yeah.
Yeah. All
right, we've been doing this for an hour and a half. Thanks, everybody. Let's take 10 minutes and we'll come back for a rousing hour and 20 minutes to wrap this up today. Okay, so we ended last time with Bill's thoughts that it should be separate. One, we should be unclear law. We should say that the law is unclear, and then any advice is tentative, and extent practicable, point them to the right direction. Now we're having disparate factual circumstances. If Bill is here, I'd like to have him take a shot at finishing the sentence, but if not, someone else can jump in.
Well, actually, I was hoping Nina would do that because she was the one who brought this one up.
Nina, do you want to take a shot at it? You're very good at this.
It's just where the legal advice depends on disparate factual situations. The automated legal guidance tool should, I don't know what to flag that and should flag that or something, just simple as that. We've already said above, give people an opportunity to, yeah.
How does the language look on the screen? Does that work for you, Nina?
Yeah, where there are disparate factual situations. I just think where the legal advice depends upon,
yeah,
disparate factual situations.
I don't think it should be that the advice is tentative. It's that the advice is limited to the
The
to the
normal,
facts,
yeah,
is limited in some way. I mean, limited to the facts in the.
or is general, yeah, or something.
But facts provided might not even be right because they might not even ask for all the relevant facts
Mhm.
because it might be so messy. I liked the language about general. That seemed better. How did that go with Nina or Bill?
Yeah, I was just, is general. And should not be, yeah.
Bill, you look at
Well, again, it's,
Mhm.
it depends. That's the thing. I don't think it's general and should not be relied upon. I mean, it should be relied upon as general advice, but I mean, the question is, it's actual situation, the advice given.
not be relied on absent further investigation or something.
Mhm.
I like to be relied upon only as general advice.
Okay.
I can live with that.
All right, Lee.
Sorry, maybe we're happy with that direction. I was just going to jump in and say the section is on transparency, and I believe we have a later section on, there's a later section on reliance, I think.
Correct.
So anyway, I was thinking that maybe what we're trying to communicate here is actually more about when, and this would apply to 6 and 7, where legal guidance depends on different factual situations, agencies should be transparent about the limitations of the advice that the user is receiving, rather than being about reliance, perhaps.
Bill, Nina?
I think that's very good. I think that's a real
Yeah.
improvement.
I
And
agree.
I wonder if it shouldn't be equally true in the previous recommendation.
Right, I agree. I think that this is trying to say flag this issue so the person's alerted.
I think it just go right. Agencies should be transparent about the limitations of the advice the user is receiving.
So get rid of
Just
unclear or unsettled.
And in that regard, perhaps you could even combine these two, say when the underlying law is unclear or unsettled, or where the legal guidance depends upon disparate factual situations, agencies should be transparent about the limitations of the advice the user is receiving. I think that works.
Yep.
I do too. Thank you, Leah. That was spot on.
And then you delete the second sentence. Well, let's see.
No, that's helpful. I think we keep the second sentence.
Yeah, okay.
Okay, I have Anne Joseph O'Connell would like to be heard. Anne.
Hi, all. So this is not directly on these recommendations, but it's linked to them, and it has both a transparency aspect where we are now and also a reliance aspect, which is the next set of recommendations. And that's when I read what we have, we're focused on the person using these automated tools and what they might be able to rely on or not rely on. But there's also a concern that the information they put into the automated tools could be used against them. And it seems important both for transparency and reliance to indicate that. So if you go to the IRS's interactive tool, it actually has a note, right? It says the information you provide is anonymous and will be used for purposes of answering your question. It will not be shared, stored, or used in any other way, nor can it be used to identify the individual who enters it. It will be discarded when you exit a topic. So I guess I would recommend a recommendation on transparency that also the agency indicate kind of what it keeps from the information. And then when we get to the reliance section, we have this issue about whether people can use the advice as a defense against non-compliance. But I think we also want to say something about people who do not comply with the advice, whether it could be used against them.
Lee or Josh, do you want to be heard on that?
I mean, speaking for myself, I would just say that that sounds like a helpful recommendation and is something that agencies did talk to us about. We did ask them questions about how they respect the privacy of users. And again, we heard agencies tell us that they make sure it's an anonymous interaction, nothing is saved, so that people will feel comfortable participating. But kind of formalizing that point as a recommendation, it would be consistent with what we hear is happening, but also for the reasons expressed, there are a lot of good reasons to make that a formal requirement.
Yeah, I agree. It's a good idea. And yeah, I agree with everything Josh said. And we'll just note that at the same time, some of the agencies suggested that to make the tools more useful, they would we're looking towards the possibility of engaging in authentication of who the user is so that they can access more of their data to sort of help answer questions. And once agencies go that route, that the concern is heightened that the agency would sort of have a record of, what question was asked by this person. So just to underscore that, I think it's a good idea.
Anne.
Yeah, I don't think it has to be one way or the other. I just think that the agency should disclose what it's doing. And I was looking at some other agency websites and they indicate that they do collect the information because then they improve on the questions and responses. So it seems like it's, some agencies just delete, some people keep to continue improvement. And I'm sure there's other aspects as well, like you just mentioned, Lee, maybe connecting it up to other data. That does make me a little nervous. But I think as long as the agency is disclosing what it's doing would be great.
Yeah, that'll be our next project in 3 years. What do you do when you link private and personal information to folks? But I think for now we disclose and we figure out what to do in the future. Okay, I like that. I think that's great. Does anybody else want to be heard on that? Okay, if not, let's move on to what is now number 7. And we can maybe move the orders around. We'll think about that, what the right order within the suites are. But we'll go content-wise, what number 7 is. Everyone take a few seconds and then we'll talk. All right, I'm going to put myself in the queue. Here's a question, and that is, when we say such updates to automated legal tools, is it clear that we're talking about like content updates as opposed to technical updates? Updates is a word that in my house that means like you're updating your version of the software or something. But maybe I'm the outlier on that one.
My comment in the queue would be to that if you recognize.
All right, Eloise, please.
I don't think it's clear whether we're talking about updates to software or substantive updates. So I have a suggestion for how to revise the sentence. So I would suggest saying agencies should update the substance of the audit, then the next thing, to reflect legal developments or correct errors in a timely, and then I would delete the "are made." And then in the next sentence, after such updates, I would hit a period and then delete the rest. And my caveat to this is that the stuff we just deleted was an including phrase. So including those made to reflect legal developments or correct errors. And I wasn't sure if there were other circumstances that we would want to be updating the substance. The current sentence I proposed has no including. So I'll just leave that blank. Also, I have to go in about 2 minutes. So in advance, apologies for missing the last hour of the meeting.
We appreciate your help. Thank you much. Does anybody else want to be heard on that? I think that language is helpful. Does anybody else want to be heard on it? Or how to add the inclusive language? Or not? All right, hearing none, that's what we'll go with for now. All right, thank you so much, Eloise. You've been very, very helpful as always. All right, let's go down to what is now number 8. So I know what this means. I'm going to ask either Josh or Lee to explain what we mean by number 8, and then I will turn it over to Bill to make sure that we're accomplishing what we're trying to accomplish. So Lee or Josh, why don't you explain what we mean by this?
Sure, I'll just quickly describe, but Lee, please add anything that I'm missing. I mean, the basic idea is some agencies use what we can describe as more of a decision tree type of approach. The IRS, for example, the interactive tax system does this. There's always going to be the same outcome depending on what people input, and it could all just be presented so that you would see the entire decision tree. If you answer yes, this is what happens. If you answer no, that's what happens. And so that's the type of the type of guidance that we're talking about, as opposed to machine learning that may change over time depending on the questions that people ask. So we were referring to the decision tree type of structure, which is appearing here as standardized answers to users' inquiries.
All right, Bill Funk.
I think I understand the situation. I mean, most of the guidance tools, online guidance tools that I've used are this decision tree type of thing. You answer one thing, it'll give you one answer. You answer something else, it gives you another thing. But I don't understand what it says. Agencies should publish all possible questions and responses. I mean, all possible questions of what? I mean, all the possible questions anybody might ask. I mean, with the decision tree, I know you don't see it ahead of time. You get it as you go along, right? I'm looking at Josh when I say that.
Yes.
So you say, they ask you one question, you say yes, and then they ask you another question because you said yes, and what time frame? Say you might put a date in there, and then that gives you something else. But you don't see ahead of time all the possible things, correct? So
that's right.
I just don't know what it means to publish all possible questions and responses. You know, am I alone here? Does everybody else understand what all possible questions mean?
No, I don't think you're alone. I think that's a fair question. We need to have better words to express the concept we're trying to express here. Maybe they don't exist. In the report, how did you, Josh or Lee, how did you describe it as, what language did you use?
The language we used was where agencies use decision tree structures and chatbots, agencies should publish content of entire decision tree. So that's the concept, but obviously the language here sounds a little broader, more ambiguous. But that's the idea, publishing the entire decision tree so that somebody could review all of it, especially as it relates to reliance and some of the other categories here.
Anne, floor is yours.
Bill's comment reminds me of when agencies on their websites used to produce essentially an index of how the website was organized. And then as things got more complex, it became impossible. And so I guess I do share Bill's concern. I was just looking at, some of the decision trees online. They can get quite complex quite quickly. So I understand the desire for transparency, but I worry about the cost of the information not being helpful. So I'm wondering if we, in the recommendation, could talk about kind of, context specific where you would provide that information.
Like, what do you mean?
Sometimes, if it's a limited decision tree, it might be helpful to have all the information. But if it gets, quite complex, I think it would just be, it would be very much like the index of the website. It's just an overwhelming amount of information.
Nina.
Several years ago, we did a most serious problem where we took a decision tree that the IRS had reasonable cause of sister. I've talked about this before, and we uncovered an assumption in that decision tree that was not supported in law. And it was only that decision tree was not public to the taxpayers. It was only because I was inside the organization that I could get access to that information, and we actually got that decision tree changed, but any untold number of taxpayers had gotten the wrong answers by the people who were using that tool. So I really think that this is a matter of, it may not be the general public looking at this, but it might be someone like me from the outside looking at the assumptions that are built into these things. And that it's actually, as more and more of these are being used, that kind of transparency is more and more important. And yes, it might be very complex. And yes, there might be times where the agency will say, we can't share that with you because this is official use only. It will show up our enforcement assumptions or something like that. But then I want to see that blacked out line to start wondering, what are they doing there? I think that's really going to the integrity of government and the use of these tools. I'll also note that, if I can just say one more thing, I think I've also talked about this other case in the Netherlands where, the court held that the lack of transparency was a violation of the European Convention on Human Rights because the agency was actually acting upon the results of, these programs and trees.
Anne, the floor is yours.
So Nina's comment has convinced me that it should be available, given obviously constraints on information that because of deliberative process or something, whatever else, would not have to be. But maybe we could, I do still think that too much information can hurt the public, and I do care about that. But I don't know, in the recommendation, as we talk about transparency, like transparency can also be about presentation. And so you don't want the agency to overwhelm with information, so it actually ends up being less helpful for the public, but to have information for people like Nina. So I don't know if we can put something in about, kind of where it goes, or, just to kind of balance the concerns that are present here. But Nina convinced me that it shouldn't be hidden.
Bill Funk.
Well, I'd like to suggest that the agency shouldn't publish it, but this would be available through Freedom of Information Act request. The number of people who could usefully use this decision tree is tiny. And so the idea of publishing it for the world, especially if there may be reasons to keep particular ones out, why not just leave it to Freedom of Information Act request to those people who really have a need or desire or expertise to use this kind of thing?
So I guess here's a fact question that is probably best for Lee or for Josh. Agencies that have done this, like, how unwieldy is it? What does it actually look like in the real world?
Agencies have not done this.
Okay.
They have not sort of provided easily accessible it's sort of decision trees or transparency around the questions and answers that come from automated legal guidance. I think the answer, though, is going to depend a lot on the agency and how many questions they're attempting to answer and how involved the decision trees are. So for instance, the interactive tax assistant has a limited number of questions that it responds to. I can't remember the exact number. Josh can let me know. It's in the 40s or 50s. So the decision tree around that would not, I think, be overwhelming, at least for tax experts, and certainly not average members of the public would be using it. But the IRS has all sorts of manuals that are actually available through its websites. And this would essentially be another manual, right? It would say, if you use the interactive tax assistant, here's the question, here's the decision tree, and here's the answer. And the idea would just be to sort of provide that level of transparency. The more complicated the automated guidance is, the sort of more involved such a transparency would be. So for instance, Emma does natural language processing, whereby you can ask any sort of question and Emma will give you a different answer. You're not going to be able to publish a decision tree there, and that's why we have these are not our recommendations, but that's why there's a different recommendation regarding transparency about the machine learning process. I do worry, along with Nina, about a situation in which there's not transparency around this. I think that one of the big recommendations, not just here, but with other scholars who have studied automation by government, is how important it is to have some amount of transparency around what's going on. Otherwise, you end up with sort of a black box effect in terms of how the law is being turned into the guidance that people are getting. So I guess the question is how to go about providing experts that guidance in a way that doesn't overwhelm the public.
If I could just also add, as Lee mentioned, the interactive tax assistant has a number of topics you can choose from, and then this decision tree process happens. It's currently at 55 topics. We have tried to figure out all of the outcomes when we click on different answers. And so we know that when, for example, the interactive tax assistant was created, the IRS knows all of the possibilities. That's how the programmers created the tool. So it's not like this would be something that would have to be created. It already exists. And it feels like something to consider is just what are the right words to get at that concept. The decision tree itself is not a phrase that would really work for these purposes. The idea would not be to talk about all possible questions that somebody could ask, but all of the questions that the agency has programmed in advance and all of the answers that the agency has programmed in advance, to the extent it's practical to make those available publicly, the agency should. But one other comment just to make is, in our research on this topic, and also specifically on tax, putting it behind the curtain of the Freedom of Information Act does create the potential that an agency may say, well, that goes to our enforcement methods, and that's not something that we can release, or at least there's the potential for that dispute. Making it available somewhere on a website that a researcher, for example, or an expert could click on creates much more transparency and access.
Bill Funk.
I was going to, I'm glad Josh finally explained to me what all possible questions and responses, what the caveat on that was, all possible questions and responses that the agency has actually used. I was going to suggest sort of at least in my mind, a compromise by saying agency should consider publishing. And then we can come up with the right language, but we understand at least now what it is that we're talking about. Again, I just, as Lee said, well, I guess that was a interactive one, but I'm worried about, overwhelming information and what the cost of the agency is in terms of trying to figure out where to put this. And and how to describe it. I just wanted to say, as a compromise, agency should consider publishing.
All right, so if we were in the room, what I would do at this point is I would look around the room and see like head nods. Are people where Bill is, or are people where Nina is? And then I just kind of get a sense to see what it is. I can't do that now. So I guess I'll say my view is I'm kind of inclined towards Nina on this one. Does Bill have friends in the audience who want to consider as the language? If so, now would be a good time to speak up. You have friends, but you know what I mean, Bill. I'm not seeing anybody. So I'll say the other way around. This will be a good test. Are there folks who think that the Nina's approach, which we just say they should, without consider, makes sense? If so, this would also be a good time to speak up.
It's a tie.
It is a tie. Okay, all right. Well, you know what? Let's go with the language that we have. But Alexandra, can you put a flag on that? We'll talk about that one next time. I want to make sure that everybody is heard on this one, and I feel like we've lost some of the enthusiasm of the group. All right, putting aside the consider language, are people okay with the language about programmed in advance? Does that do the trick for people? Maybe this is a good question for Josh and Lee. Does that work for you?
I mean, again, just speaking for me, Lee and I aren't in the same place, but yes, yes, that's the idea of the decision tree. It's all programmed in advance.
Lee?
Yeah, I think I'm okay with it. I mean, one issue is that the technology is going to change and some of this is going to get outdated, but I think based on what we know now, this looks okay to me.
All right, Bill Funk.
The question, it says to provide an immediate and comprehensive source of guidance to users. And as I understood what Nina was saying, is it's really not the users who are going to be using this particular decision tree information. It's other people. So maybe we should just change the say to provide a comprehensive source of information regarding the legal guidance tools.
Do we even need that explanatory sentence? Could it just end after it has programmed in advance?
I mean, I don't care, but at least would explain why it is we're recommending it.
Okay. Nina, did you want to be heard?
Yeah, I mean, I put in the comments that, I view this along the lines of being able to review the privacy impact assessments. I mean, I spent a whole bunch of time the other day reading it's in a reading room on the IRS website. It's required by law, obviously, but if you've ever read through them, they're not something the general public is going to read through, but they're out there because of transparency. And I sort of view this the same way. It wouldn't be on the decision, it wouldn't be on the tool's website. There'd be a link, or it's part of what's posted on the website, and inquiring minds can track that. So I think that addresses Bill's concern about confusion.
Bill, does that address your concern about confusion?
Well, I mean, I don't give up on my consider issue, but I think I think that what we have now is other than that is fine. I like the way it's been rephrased.
Okay, we'll talk next meeting about consider. So let's put that aside. Anybody else have any other thoughts on what is now recommendation 8? All right, hearing none, let's go to recommendation 9. Let's read it and then talk. All right, so this is the one that Lee was discussing a bit earlier about the other way of doing this. All right, Bill.
I just gonna make the same comment and say, I think it should be consider publishing rather than shall publish.
Yeah, I think that is fair. We'll talk about that. They should be together, though. I agree with that. There's symmetry there. All right, beyond that, Nina, yes.
Well, didn't we, when we had the report on artificial intelligence, this is getting more, if you're getting into machine learning, we've made recommendations about this. And so I think that the staff could go back and see what we've said. We had a whole discussion about transparency and working on those recommendations. And we might want to look at that to inform what we say here. Did we say should consider? Did we say you should do this? You know, what did we do?
That seems like a very good suggestion. I'm going to ask, Alexandra, Jeremy, did we standardize our language here? Did we do the same thing of this one as we did with that one?
Hey, that was actually a statement, so it doesn't mean numbered recommendations.
Right.
Say things like consider, should consider. It does address transparency, but it's more the nature of a general discussion.
Okay, can I ask you between this meeting and next to just go back and look at the language that we used? All right, perfect, thank you. All right, subject to that, we'll see what we said last time. Does anybody have any other thoughts on what is 9? Okay.
Lee had a comment.
Oh, I'm sorry, Lee. I apologize.
No problem. Actually, sorry, I just am sort of still reviewing 8. I was just wondering about how people felt about, I think the sort of beginning of it, when legal guidance tools provide standardized answers to users' inquiry, I think that could be a little bit confusing. And I don't know that it's necessary. I think maybe it could just say agency should consider publishing the questions and responses the agency has programmed in advance.
That makes sense to me. Bill, does that give you heartburn?
No, except I wouldn't that also be true for when the legal guidance tools learn to provide different answers, because they do get programmed in the first place. They get programmed in advance, but then they're supposed to learn over time. So I'm not an expert here, but it just seemed like that would make 8 include the stuff in 9 as well.
Is that true, Lee?
Well, I don't think in the case of machine learning, I don't think that they would be programming the questions and answers in advance that the users were going to receive.
Really? I mean, I thought they would learn over time. They'd program something as an initial thing, and then over time.
I guess that's right, but I would be okay with them sort of publishing what it is or revealing what that was initially programmed, and also in a case in which there's machine learning, then sort of being transparent about how the machine learning is happening. So the machine learning would require an additional step in transparency, but I think it would make sense in any event to publish, to reveal anything that they have programmed in advance in terms of questions and answers.
Well, I certainly don't know enough here to know what actually happens out there. I mean, if the problem was just the language of the introductory language and what's now 8, you could just make it when automated legal guidance tools do not learn to provide different answers to users' questions over time, then you'd pick up could publish questions and answers the agency has programmed in advance. I mean, you could make them either or clearly by using the language, and 9 is the tipping point.
Lee, what are your thoughts on that?
That sounds good to me.
Josh, do you want to be heard on this?
Oh, that sounds good.
Okay. So over the weekend, I took my daughter to the National Archives, and I kind of wonder, when they were drafting, say, the Constitution, how did they do this without the red line so everybody could see the changes at the same time? What a remarkable age we live in.
And look what a good job they did without redlining.
I know. Alexander has the hardest job. Are you ready for us to go next? I thought we were gonna, does that work now? I think that does work. Okay, let's look at number 10. Is this a new comment, Lee, or is that your old comment? All right. Does anybody have a problem with 10? That seems pretty self-explanatory to me. All right. Hearing none, let's look at 11. Does anybody have a problem with number 11 or addition, subtraction? Here's a question that I have on this one. This is about agencies, but also about the private sector. Do they typically provide these disclaimers? So say you're doing it with your insurance company. Do they have these disclaimers that you're not talking to a human? Or is this something that we're adding above and beyond what other entities do? Josh, you're nodding your head.
This one I did look at when we were just trying to learn a little bit about the best practices in the private sector. I mean, this is a huge topic for any company that wants to create one of these for their website. And one comment that often was made is that you should tell your customers that they're not actually speaking to a human being, at least put a disclaimer somewhere. So that was one of the motivations for this.
Bill.
I just wondered whether we should say, rather than when automated legal guidance uses natural language processing, just say when agencies do not provide human interaction with their advice, agencies should provide disclaimers that the speaker is not human. I mean, what if it's not natural language, but is this sort of automated stuff? A lot of people might still think they're talking to a real person unless there's a disclaimer.
All right, so what would the proposed language there be, Bill? When automated legal guidance may...
How about start with agencies should provide disclaimer that the speaker is not human when the speaker is not human.
When applicable, agencies should provide disclaimers that the speaker is not human.
Terrific.
Does that still work for you, Josh? Are we missing something there?
I guess the only thing I would just say is you might want to consider whether you want the word speaker, because right now it reads when applicable, agencies should provide disclaimers that the speaker is not human. I think you mean that the automated legal guidance is not human.
Yeah.
The automated legal guidance tool is not human. Yeah.
Okay, does that work for you, Bill? Thumbs up. All right. Would anybody else like to be heard on this one? All right, let's move on to the next suite here, which should be we have the last one at the very end about like ongoing training, but this is the last kind of heavy lift of suites here. We probably won't make it all the way through, but we are well on our way to doing this in 2 meetings rather than 3. So let's knock on wood on that one. Okay, so let's talk again, big picture before we get to individual recommendations. We have to incorporate Anne Joseph O'Connell's thoughts about reliance somewhere here. Is there any other big thoughts we want to add to reliance? Anne, are you still with us?
Yes, I am.
Can you please share where you kind of think your thought would fit in here?
1 second, I'm just getting it
Sure.
larger on my, whoops.
It's really super tiny on my screen. I keep leaning into it.
Yeah, no, that's why. So can we go down? Yeah, I feel like it either could go with the last one. You know, in defending against hold on a second, I'm sorry.
Sure. No, take your time. That was unfair.
I guess I would add another number just to talk about the flip side. Like what happens if the person does not take the advice of the automated tool? Presume, you know, the agency should state presumably that it couldn't be used against them, or maybe the agency would want to decide if it is in fact collecting information about them that it could be used against them.
Josh or Lee, as far as you're aware, do any agencies use the information against the user?
No, I'm not aware of any that do at present.
That doesn't act like they still might want to, but I'm just curious as we frame it, whether we are coming up with things that are not what they do, but your point is still.
But we did, I mean, we did ask questions again about how do you protect the user's privacy? What are you doing with the information? And so we did talk with agencies about that. And if there's a more general recommendation that if the agency is collecting information, they should disclose how they are using that information, that might, or how they will use that information. Something general like that might cover these concerns.
Bill, do you have a new comment?
Well, I do, which
Sure.
was, I mean, I thought that we covered that under transparency, right? In other words, if the agency is using this information, is going to use this information, it has to say so. And I thought we said that up in transparency. I can't see it now because.
We did, but Anne wanted to.
Oh, I understand. I understand Anne's comment, though. Anne's comment is it's a reliance issue. In other words, if the agency should say, you can rely on our advice, they could say that, or they could say, you can't rely on our advice, or they could say, if you ignore our advice, we will use that against you, all right? That you acted knowingly in violation of the law because you didn't take our advice, because we know that you got our advice. And that's, I thought, what Anne was addressing. Yeah, and so that's a reliance issue, not a transparency issue. We say that the agency can use it against you. Now, I can't believe that any agency would do that. So I don't know. I think I'd leave it out altogether, but I certainly understand Anne's point.
Anne, the floor is yours.
Yeah, I'm fine with just mentioning it in one place and not in both places. I think it's both. I mean, if an agency could conceive of doing it, then I guess I have a little bit of me that thinks you should have something in reliance to maybe guard against that. But it's primarily about a transparency issue that, as the recommendation was initially drafted, they're all about kind of, I don't know, like good things coming to, or defenses to the person seeking the information, but there could be a bad side as well. And where that goes to the person seeking information, it doesn't matter to me.
So you're okay with where we have it in transparency, the language? Okay. All right. Thank you. Thank you, everybody. All right. Let's scroll back up then and go through this. Any other general thoughts on reliance? Okay, if not, let's look at what is now number 12 on the screen. All right, as I read number 12, is that reliance or transparency? I don't know who I'm asking. That looks like transparency to me.
I can jump in here and I think, explain,
Sure.
Aaron, where that came from, which is that in order to build a reliance argument, you would need evidence of your interaction. And at present, a lot of these tools don't provide you sort of a written record of the communication. So that's why it's falling in reliance, even though it seems like a transparency issue.
I guess I don't feel strongly. I suspect that someone reading this without that explanation you just gave might say, that sure looks like transparency and not reliance. But I don't feel that strongly. Does anybody think we should does anybody think we should move it, or are we okay with it in reliance?
I'm okay with it here.
Okay, all right. Anybody else disagree? I'm fine with it as well. I just want to flag it. Hearing none, that's where it goes. Content-wise, are we okay with it? Does anybody have any thoughts on the language? Okay, all right, let's look at number 13. All right, so Josh wants to be heard. Before we do that, I have a question about number 13. This is I had flagged a version of this for the ACUS staff to say, like, what have we said before? So can I ask kind of the history on this one? Is this consistent with the language that we've used in others, or where is this language coming from? I'm not sure if this is directed to Jeremy or to Reeve.
Jeremy, I might have to defer to you on this, or Alexandra. Go
back and look at our guidance recommendations.
Okay, all right. Well, we can look into this further. Josh, the floor is yours.
Thanks. I actually I couldn't type fast enough. I had a comment on the previous.
Oh, sure.
Previous one, just one word.
Let's go back.
Sorry. The word was about retaining. I think the language was allow users to retain a written record. The language we used in the report was download a written record. The whole idea is that people can't get it right now at all unless they take a screenshot of every single page.
Oh,
so
I'm with you.
I don't know if a word, instead of if download becomes outdated in the future, maybe obtain. Agencies should allow users to obtain a written record or something like that, because retain like retaining nothing. Yeah.
No, I agree. I think that's a very helpful edit. All right. Does anybody disagree? Hearing none. All right. Thank you. Let's go down to the one here. Does anybody have a thought on what is now 13? Which, you know, I like the way that we do it here, which is, you know, there's all sorts of law. This question is not limited to this particular project. You know, how much people can rely on what an agency says on guidance is a big issue. This is just a specific application of that issue. So I like what we've done here, which is, you know, you have to say what it is. There's a whole bunch of law. Was it Frankfurter who says you have to turn square corners with the government? And Bill's looking at me. Am I wrong about that? Am I misremembering?
Holmes.
It was Holmes. There we go. That's why I'm glad Bill is here. Eloise is my expert on wordsmithing. Bill is my expert on Holmes. There we go. But my point is here, there's a lot of law floating around out there about how this works. And we can't, at least I'm speaking for myself, we can't change all of that. That's not our function here. Our function here is to provide guidance and help for people as they navigate it. So I kind of like them saying, if they're going to do these things, then they have to, like, at least, you know, explain or think how it works, rather than us trying to, you know, change that kind of big thought. But that was my thought on this one. I'm happy to hear other people's thoughts.
I think your thoughts are entirely correct. I mean, we can't change the law or anything. The only thing not clear to me here is they should consider this, but doesn't say they have to tell people.
I think it's the next one is the transparency on that.
No, that's transparency with the departing.
Okay, so what's the distinction? Maybe I'm missing it.
Well, if the agency wants to let somebody use this as a defense, they should say so.
Okay, no, I'm with you. Correct. Okay, I like that. But could we add that language in 14? Like, by contrast, if an agency thinks it should be bound, it should also say so.
Well, we have in now 14 and 15 prominently announced the fact, prominently announced that fact. I think the prominently announced the fact should be in 13 as well.
Okay. Okay, I'm with you.
We can look back at 2019 1 on interpretive rules and 2017 5 on policy statements. They both read interpretive rules or written policy statements should also indicate the nature of the reliance that may be placed on them and the opportunities for modification, rescission, or waiver of.
Okay.
There's in 13, you have to have an introductory, and if it, you see, it could consider whether they should have this reliance. But if the agency determines that the good faith reliance is a defense, it should prominently announce the fact to users. Or it should prominently announce that its decision to users.
Yeah. All right, Josh, I'm looking at the bottom of the chat. Is this a new comment or from before?
No, that was from before.
Okay. All right, so I know this is a big part of the report. So Lee, Josh, does this language as Bill has put on here, does this work for you? Either one. I guess I'll call on Josh first this time, then Lee first next time.
Yes, I mean, it goes even a little beyond what we had focused on in terms of making the clear announcement to users that they can rely on it. We were talking more about what the agency do when we get to the ex post part of this, the audits and the enforcement and all of that. But from my perspective, this works.
Lee, is that true for you as well?
Yes, that's true for me as well. I guess the only thing is I'm trying to sort out a little bit. So the way I see it, there's the penalty issue, and then there's the bindingness issue. And so that's number 13 is penalty, and number 14 is bindingness. And then I'm just sort of sorting out what is 15. Is it just a combination of the prior two? I'm just wondering if we need 15.
Yeah, is there a difference between a penalty for noncompliance and consequences for noncompliance? I mean, consequences is bigger than penalty. So would we change the language, the word penalty in 13 to consequences, and then delete 15?
Or penalty or other consequences?
Or that's even better. Penalty or other consequences. Thank you, Nina. And then we would delete 15. Does that work for you, Lee?
Yeah, I think that works better, and it makes clearer to me what 13 and 14 are about then.
Bill, does that work for you? Okay. Well, this is record time. This is amazing. This is great. All right, let's look at the last one, and then I think we can end this meeting early, and we'll come back and finish this up on our next meeting. So let's look at number 15 here. And we have to the GSA. Here's a question maybe for Matt or Reeve. Does GSA know that we're saying this?
Reeve?
I don't believe, no, I mean, we'll contact our GSA.
Yeah, they might like to know that one. All right. This is a good part of the, oh, Jim Tozy. Jim, the floor is yours. I can't hear you, Jim.
Are you finished with 15?
We're working on 15 right now.
Oh, I'll comment after that.
Okay. All right. So we're gonna ask, you know what, I think just for the, oh, John Cooney, John, yes. I can't hear you, John.
I wonder if this is the same kind of comment Jim may have from his OMB days. This is really a practical question for the consultants. There isn't, when you get to the GSA and the outside consultants, there really isn't anything else in here that discusses the outside consultants. And as Nina said, when we did discuss outside vendors a lot in the AI and machine learning statement. So my question for the consultants is, you learned very interesting material in the course of your interviews, and it's a practical question whether there is anything in those interviews that might make a best practice for other agencies, and whether there's something that it might make sense to do to inform the agencies who are just getting their feet wet as to situations in which you ran into something that's either very positive or very negative about use of outside consultants. That's it.
I think it's Lee's turn to go first. Lee.
Yeah, I'm not confident to sort of provide best practices around this yet. I think the agencies are still in their relatively early stages. I mean, in a prior draft of the report, I think we were a little bit more sort of explicit around some things that we thought, but at this stage we thought actually experimentation is more important, and we didn't want to try to dictate sort of a certain set of practices around this, but rather that we recommend continuing evaluation of it. I mean, some of the downsides that we did hear about of using outside vendors were that it can be more time consuming. So the agency sort of has to go through the interface of the outside vendors and then sort of work with them to input the questions, make sure everything's okay. So it can sort of duplicate time. There isn't right now one platform that agencies are sort of collaborating on. And so there's sort of a multiplier effect across the federal government. But we didn't feel comfortable just yet trying to dictate one set of practices, but rather just wanted there at least to be some cross-agency evaluation as things developed further.
Yeah, and I'll just add, we heard from all of the people we spoke with about different vendors that they were using. And so our thought with this recommendation, which was basically the same one in our report, was that it's clear that you have multiple vendors all trying to do the same type of thing. At least the government should be aware that this is happening. Are there any benefits to trying to do something internally or create something that's more uniform across at least the federal agencies? But we didn't take any type of position on that. We just wanted to flag this as an issue because one thing that we learned in all of these interviews is just the crucial role that all of these outside vendors play in making the automated legal guidance tools possible.
All right, does anybody have any proposed languages? Obviously, GSA is going to chime in and they might have some thoughts about what that looks like. But putting that aside, from the committee's perspective, does anybody want to change anything in 15? Add to it, subtract to it, add something else? All right, hearing none. Jim, you had thoughts. We're done with 15.
Oh, yeah. Thank you. This is some more broader, it doesn't fit into any of these particular categories. And maybe the committee could think about this next week. You know, ACUS stands on top of the mountain. It looks to all of the issues and it comes up with recommendations for how agencies work. And when I look at all these recommendations, I think they're right on. There's one thing that, and this might be a slight overstatement on my part, that maybe you could give some consideration to, and it's probably an overstatement, but it's more of a wake-up call to the agencies. And I think the thrust of what this report is doing needs a serious look on a continuous basis, because all the data I work with, the administrative state continues to grow. And I think if some of the issues that are addressed in this report aren't looked on a continuing basis, there's a chance that there'll lead to increasing non-compliance, and the federal government can't enforce all this stuff. Now, just a brief example, I'm working on, one of the issues I'm working on is the regulation of derivatives in financial markets. And this is a very difficult issue. And if you ask even people that specialize in it, any particular issues, there's different views. So the second thing I'm asking is whether the government should provide forums where people can exchange ideas on this. Now, the private sector does that. There's a thing called an interactive public docket. Wikipedia has a page on that, where the regulated community gets together, and it's very public, and you have a question, and another person answers, and there's a dialogue. The problem is the government, I've asked the government to do these on certain rules, where if they hosted that, they could involve it, they could see questions asked, and I have no takers on that. So my question, maybe you could give a thought of the longer term consequences of follow through on this report and have that part of the recommendations.
Okay, I'm just thinking what that would look like, because I agree. I think what you're saying is correct. It's also not limited just to this report. We could have done that for a number of other reports as well. So I hate to throw it at you. Matt, do you have some thoughts on that? Maybe we've lost Matt.
You did lose me for a sec. I lost you for a second here. Sound. Reeve, can you address that?
Happy to. Aaron, you mind sort of restating about, I kind of.
Sure. So Jim's point, which is, you know, ACUS, we see a lot of things, and we come up with like recommendations for agencies and things of that sort, but we don't know how they're implemented, and we don't know as the agencies grow, there's just lack of kind of communication between different parts of Leviathan here. So like, you know, in the public sector, in the private sector rather, they have places where people can, you know, meet together and talk about problems. What do we do for something like this here, which will be an ongoing problem? We're going to have, you know, future versions of this as AI becomes better. We're going to have lots of this. What can we do to try to make this not just a one-off, but kind of more of a ongoing process? Is that a fair summary, Jim?
Yes.
Yeah, so it's definitely, it's a pretty foundational question, I guess. I mean, you know, we have ongoing programs like our Interagency Roundtable or the Council of Independent Regulatory Agencies, where, you know, we discuss ongoing issues with agencies, sometimes directed to specific recommendations or topics that have come up in specific recommendations. And then, you know, there's just sort of an ongoing dialogue that we have with our agency members. So it's a good question. I mean, it's something we probably want to give some thought to, how, you know, particularly on the implementation front, are we ensuring not only are agencies adopting the existing recommendations, but ensuring the recommendations are sort of.
Yeah, maybe you could take a look at it between now and next week, because I just think this issue is going to grow in importance, and whatever the shortcomings are, it may be better not doing anything. And there might be a way that the government can host a forum where people exchange ideas informally and they answer each question, so that I just would hate to see all this great work come to this report. It goes to the agencies and there's not any follow through, because I think what you've identified in this agent. People, I mean, we can't, our website, we can't answer 10% of the questions that we get every day on all over, on everything. And that's, we're just one people that answer questions. So there's definitely a market for, and all the ACUS reports I've been involved, there's definitely a market for this product. People would really appreciate some place where they can have a dialogue or some on a constant basis, because I get more questions on that general issue, I think, on any we get. So maybe you could just think about that between now and the next meeting.
I mean, we do make, Aaron, we do make provisions sometimes for some to institutionalize some kind of dialogue where ACUS plays some role as a convening a working group or something like that, or a forum. I don't know if this is an appropriate instance in which to do that, though.
Well, take a look on the Wikipedia on interactive public docket, or go to our website and put that in. You'll see tons of these things done, but there's no government involvement, and the government resists. I asked one agency, I said, you have all these experts in this area. And I said, I know they can't give opinions on the web, but they can sort of look at a question and say, look at this. And they do not want to participate in any of those. And I'm not sure of all the reasons.
Well, again, I think that is a bigger question than this one, but let's think about it. And I think let's circle back when we have the next meeting.
Fine.
But, I mean, because I thought that Matt, it would be helpful, or Reeve or somebody from your team, if we could find an example of a recommendation of an ongoing kind of process. The committee might not want it, but I'd at least like to see it so we can kind of know what that looks like. Is that something?
I mean, we have all sorts of examples of that. It's not we do that with some frequency.
That's right, but I don't remember one.
Yeah. No. I know, and I wouldn't suggest that you should remember, but we will furnish you some examples or options from which the committee might choose.
Perfect. Thank you so much. All right. Well, I'm about to say we're gonna end a few minutes early today. We've covered a lot of ground. Thank you, everybody. If I have Bill Funk has a question, but I'm still, if it's okay, Bill, can I wrap up?
I had a question that I wanted to get answered before we ended.
Sure. Go for it.
This is really for the reporters. As I understand it, third-party contractors create these guidance tools. But did I understand that actually they maintain the server as well that does this stuff outside? It's not part of the government server? For Lee or for Josh?
That issue we actually did not address, at least to my recollection, with the representatives we spoke with. The product itself is always, I mean, in almost all cases, something that the vendor created, but where it's hosted or if there are outside servers that are used was not, we didn't get into any of that level of technical detail.
Bill, did you check those questions? Did
Yeah,
you check those questions for regulations.gov?
Well, the reason I asked was, I again don't know the answer to this, but if we were going to have a connection between the guidance tool and with a link to a government website, and if that's from a private server to a government website, a cybersecurity issue. I wonder if there's a cybersecurity issue there, because then you'd have to make sure that the vendor's thing is cyber secure as well, given that link. That was the reason I asked that. If they're not actually maintaining the server, then I don't think it's a problem.
Yeah, we didn't focus on, I mean, there's certainly there's certainly a lot of technological issues around the automated legal guidance. We didn't focus on the technological side as much as on the legal side and the development of the law, as well as issues such as reliance. We did find that they were using, the general strategy right now is to use these outside servers, but as Josh said, we're not sure about the details of the technological maintenance over time. The agencies did suggest that They ensure that all federal law is followed in terms of privacy issues. But I don't have any more details than that. At the present time, the agencies aren't using having users authenticate and using users' personal data. But it would be a much more significant issue once agencies start to have users authenticate.
You said outside servers.
Oh, I don't know if outside vendors. I don't know anything about the servers.
Okay.
Yeah, I mean, I would assume this is a broader issue that frankly, I don't know the details of in terms of, I see sort of Nina nodding her head, but I assume that there's issues with agency websites generally. In other words, this particular issue doesn't seem unique to the automated legal guidance question. It seems to be a broader question about who's creating agencies' websites, what servers are being used there, who's maintaining those websites. So sort of a broader question about agency uses of technology that I don't know the answers to.
Thank you.
All right, so closing thoughts for this. Thank you, everybody. We appreciate it. I think we made a lot of progress today. I would sure like to do 2 meetings rather than 3 meetings on this. We're almost there. The end is in sight. To make that happen, I ask that between now and then, the preamble, if you have thoughts on the preamble, we're going to go through it line by line. We're going to do it that way as well. If you have thoughts you could pre-submit, that would be really helpful as we kind of go through and plan this out, so we don't have to go back for a 3rd meeting. But the end, I think, is in sight. This is looking really good. We'll have our general suite with that language when we come back next time. We have a few homework assignments for ACUS staff. Knock on wood, we can get this done in a couple of hours. So thanks, everybody. Our next meeting, we'll send around the email, but our next meeting is Tuesday, April 25th. From noon to 3 Eastern time. But we'll make sure that email is sent out as well. Again, on Tuesday, April 25th, noon to 3 Eastern time. And Matt, do you have any closing thoughts?
No, thank you, Aaron. It's you're I guess ending us about 6 minutes short, and sounds like you're well on your way to completing this at the next meeting. So that's good news, and we'll attend to the assignments that you've given us.
All right, thanks, everybody.
Thanks, Aaron.